Hello, folks. Thanks for coming to the office hours today. We're going to give people a minute or two to file in. People seem to be showing up. So we'll just give people a little bit more time and then we'll get started. Okay. Hi, everyone. Welcome to the eighth CoveyLaw Tamizdat office hours webinar. Office Hours is our monthly series, and each session focuses on one broad and timely topic related to U.S. immigration issues with an emphasis in the cultural sector. My name is Matthew Covey. I'm the executive director of Tamizdat and a partner at Covey Law. I'm a middle-aged man with a white beard and no glasses at the moment, but normally glasses. I'm wearing a striped t-shirt. I'm joined by my colleague here, Covey Law Associate JR Strauss. At Covey Law and Tamizdat, we hold ourselves accountable to the work of undoing oppression and advancing equality to overcome the bitter history of segregation and racial inequality. As part of this work, we must start by acknowledging that we are broadcasting today from the ancestral and unceded lands of the Lenape people. We pay respect to the Lenape elders, past, present, and future, the traditional custodians of the lands on which we convene today. Now, immigration is complex, and we can't hope to provide comprehensive coverage of any topics. So we got to start with a disclaimer, of course. We're lawyers. The information we provide today should not be taken as legal advice, which can only be given regarding the circumstances of a specific situation. We will be giving you the best information we have right now. And you should feel invited to reach out to us if you have specific questions that we haven't answered, or if you're making important decisions based on what is discussed here today. Also, if you're watching this video after July 15th, 2026, some information could be outdated by the time you hear it. So again, please reach out to us for updates. If you're a Covey Law client, reach out to your attorney or case manager. And if you're not, contact Tamizdat's pro bono hotline, Tamizdat through the sign up that's linked at tamizdat.org/Tamizdat. In the next hour, we're going to be talking about best practices for non-US citizens who are entering the US. We'll be focusing on the experiences that travelers have at ports of entry when they encounter US immigration and customs officials at airports and land crossings. We'll talk about recent policy changes as well as both real and commonly perceived risks. To start, JR, you want to introduce yourself?
Hi, I am JR Strauss. I am an associate attorney in Covey's General Immigration Unit. I am a middle-aged man with a grayish, darkish beard. I sort of look like Santa Claus after he spent some time in the Merchant Marine.
That's
Uh,
fantastic. You should have
I'm
my shirt.
I'm also a former member of the American Immigration Lawyers Association New York chapter, CBP liaison committee. So some of what I'll be talking about today is based on that experience and just what's been observed in the last couple of months, because I think, as everybody knows, and Matthew, as you know, a lot has been changing.
Yeah. And that's a lot of the reason why we decided to do this particular topic today, just because there's a lot that's changing. There's a lot of perceptions of what's changing, and some things are, and some things aren't actually changing. And so we're trying to give you all some facts to work from and some advice. So let's start with this. JR, do you want to take the lead on saying just, well, what should travelers consider before their travels to the US?
Yeah, and this also lines up with a question somebody asked, and I know we're going to get to questions towards the end of it, but it seems like a good opportunity to address what we can right now. And the question is, should people bring U.S. contracts, copy of USCIS approval notice, proof of stature as a performing artist, and proof of ties to their home country and return ticket? Uh, so I think there's a couple of things to consider when entering the United States and preparing to enter the US. And some of it's going to have to do with what status you're entering in. Are you coming in as a non-immigrant under a specific visa classification, like an O1, and I think a lot of people on this call that probably applies to them. Oh, or if you're coming in, and Matthew's going to discuss a little bit in a minute about somebody that's coming in under maybe a visa exception, which is different, or if you're coming in under a special classification, for instance, if you're going to be admitted under a process called the I-193 form. Uh, every process is going to be a little bit different and require different documentation. And also, we're hearing varying news from some of the ports about what you should bring. For the most part, if you are somebody that's on a P visa or an O visa and you're coming into a port like JFK or Newark, which are some of the most common ports, JFK Terminal 4 sees 75,000 international visitors a day on average. So more likely than not, a lot of our clients will be coming through that port. Usually you're just going to need your visa stamp and a passport. There's been some questions recently about how many pages should my passport have because do I need to have available pages for stamping? Uh, ink stamps into your passport have been phased out largely by CBP. There was a pilot program that started at JFK and Newark that saw a greater reliance on the I-94 system to track entries and exits. So it is not uncommon to come in and not have your visa stamped. But I'm telling most clients it's best practice to have a couple of clear pages because that was just the old rule, and it's better to comply with some of the older rules, especially pre return of Trump, just because I think that's reliable guidance and it will avoid trouble. One thing that we have heard that it's really going to depend on your circumstances will be JFK has in some cases been asking to see copies of the I-797 approval notice. Uh, that should not be necessary, but for anybody that, especially somebody that's coming in for the first time on an O1 visa, it's something you may want to check with your attorney about if that's going to be required. Uh, for a Canadian national, Canadians are what's called visa exempt, meaning that they generally don't need a visa stamp to enter. You will need to show your original I-797 approval notice, especially for the first entry. I think as Matthew, you know that some people will show copies of their I-797. Not everybody is comfortable traveling with their original notice. Uh, I think the default is probably having the original is going to avoid some headache, but I don't know if we've heard of people being denied entry for presenting copies of the I-797. So again, if you're worried, speak to your attorney beforehand. But to go back to that question I initially referenced, you're not going to need your full petition. You're not going to need proof that you're an artist. An O2 traveler, you may want to have copies of return tickets to show that you are going to return home. That is generally best practice. Um, and that has to do with ties to the home country that is more of a consular issue than it is something that comes up at CBP. But never a bad idea to have access to that documentation. And when we talk about special cases, which Matthew's going to talk about the some of the B1 exceptions, or somebody that's coming in that may have something more novel, an attorney letter may be something that your attorney will have drafted for you. We sometimes call those back pocket letters. That's if you're in a special case, you'll know that you're in that case, and your attorney will hopefully have told you what to bring with you because CBP they are scary, and it's not a favorite pastime to talk to them every time, and we understand that. But they have indicated that they will accept documents and letters from attorneys so you don't have to advocate a complicated situation yourself. It can be really hard to express something like, I'm coming in based on one of the B1 exceptions, or I would like to be granted the 10-day grace period because I need to have extra time to depart. Sometimes an attorney letter is going to do that heavy lifting for you. So don't be afraid to talk to your attorney, even if you have to spend some money to have them draft a special letter, because sometimes that may be necessary if it's particularly complicated. It's one of those things that it's peace of mind. Because we say it's back pocket because that's where it lives. Sometimes you don't ever have to take it out, but other times, if CBP doesn't understand what you're asking for, or if you're traveling under a visa stamp that was issued for another employer, but you have a new approval notice, that's something that you may want to show the approval for that, and maybe an attorney letter will help clarify why you're doing that. So there are cases where you want to have extra documentation, but hopefully you'll have, talk to your attorney beforehand.
And if you don't have an attorney, if this is something, if you're coming in on ESTA or on a B1 visa to do something that's professional but not employment, so you don't need one of those employment-based visas, that's also something that Tamizdat can help with, giving you templates for letters that the person, the U.S. organization or entity that you're working with can provide those invitation letters, and that can help smooth that. It's just important, if you've been flying for 9 hours and you arriving, you're probably not going to be fresh and not necessarily going to be doing your best thinking at that point when you find yourself face to face with a Customs and Border Protection officer. So if you've got a letter that kind of it lays out whatever it is that you need, if you need something that's not normal, then or not routine or that you're not used to at least, that's going to make the process go a little bit more smoothly.
And that's a really
Working
good
out.
point. People coming off of a flight, you're going to be tired. You're going to be a little punchy, probably. CBP does take that into account. They're looking at behavior sometimes. So it's very easy for us who deal with this every day to say, just relax and try and, be okay. But for you on this call right now, it may be like the only time you ever deal with law enforcement, and it's scary, and that's something to consider. Like, try to remain calm, be aware that they are looking for, behaviors. They are using relatively complicated technology now to track entry. They're looking at facial recognition. They do have files on some travelers that are being cross-referenced. I think as of now, the technology is probably not the most advanced as much as, Doge and Elon Musk would like us to believe. But it is something they're piloting, and it was something that was in the works before the Trump administration. So, without a more Orwellian fear, they're trying to use technology to the extent that they can to track people. And anybody that comes in on global entry, you're, you're part of that program now too. That's another thing to consider. I just want to bring that up. Those who are traveling on global entry, be aware of what information and what visa is linked to your global entry, especially if you were in a different classification when you initially applied for that. That can sometimes lead to complications. We talked about the I-94 very briefly. We're going to talk about it a little bit later in this call. But for the purposes of making sure your travel records are consistent and there is no confusion in the future, just be aware of what you're coming in, what you're asking. But that actually leads to the next topic that I think we want to discuss right now. Matthew, we talked about special cases, and there are special cases, and the visa exceptions are things that come up really often. And it sort of sounds like employment. Is it employment? How is it a special case? What are we talking about when we talk about those exceptions?
Sure. Okay, so this is something we've talked about in a number of webinars, but it is such a perennial question and it does impact how people enter the US because oftentimes people in these exceptions aren't, by the nature of it, they're not going and getting a visa before they come to the US. They're just showing up and hoping things work. So I want to talk just briefly about the situations where somebody coming to the US to do something professional doesn't actually need an employment-based visa. There's a lot of confusion around this, and we spend a lot of time trying to help people understand what is employment and what is not employment. And I think the best way to look at it is this. If you're coming to the US to do something professional, start from the assumption, you're not coming to visit you're not coming to visit your relatives, you're not going to Disneyland, you're coming to do something related to your work. Start from the assumption that you're working under US law, whether you're being paid or not, you're working, and then explore whether there's an exception to that rule, which allows you to come on ESTA or on a B1 business, like business visitor visa, B1 or even a B2 tourist visa. So I'm going to run through a number of exceptions to that rule and try to summarize quickly what are the situations when somebody coming to the US to do work-related things can do that on ESTA without a visa if you're coming from a visa waiver country, or on a B1 visa or a B2 visa if you're coming from a non-visa waiver country. First of all, The main topic is whether you are coming to the US to do something that is work related but not employment. And that usually has to do with, are you coming to uh, have a meeting, to do research, to sign a contract? Those kinds of activities are generally seen as business related but not working. Those are things that you can generally do in the US without having an employment-based visa. There's a lot of gray areas around that, and that's where people can get in trouble, or that's where a lot of the questions come from. I'm going to speak briefly, specifically about performing artists, because that's a large bulk of our clientele. Um, there are a handful of exceptions that allow performing artists to come to the US to do work related things that even can be performance related, but that they don't need an employment based visa for. You don't need a P or an O visa to do it. I'm going to talk about them briefly because if you find yourself in a situation where you think one of these may apply, I encourage you to not try to make that determination yourself. This is something you should definitely reach out to Tamizdat or reach out to CoveyLaw to get advice. Just say, like, this is what I'm coming to do. Do I really need a visa for this? So the exceptions that are most commonly used are a showcase exception. Oftentimes, if you are performing at a bona fide industry showcase event, usually music or theater or dance, where the principal reason that the audience is attending is not because they're there to be entertained, it's because they're there to consider employing you in the future. Chances are good that you don't need an employment-based visa to do that, especially if you're not being paid. Um, you should have an invitation letter that is from that event explaining why you don't need a visa. Um, Oftentimes, if you're coming to perform at a cultural event, which is free to the public and paid for by your home country, so this is kind of falls under a cultural exception. So if you're French and you're coming to perform at a French event that is free to the public, um, and paid for by the French government, you don't need an employment-based visa for that. You can do that on ESTA. You can do that on a B1 visa. In some situations, but again, you need to have an invitation letter from that US entity or that French entity that is bringing you to the US to explain when you arrive. There's a back pocket letter that JR was talking about to have on hand. So if you get questioned about why are you arriving with lots of musical equipment and you don't have an employment-based visa, you're going to want that invitation letter. If you are performing at an event which is part of an academic program, there's a very specific exception that allows performing artists to do their work at universities and colleges under some circumstances and be paid for that work without having to have an employment-based visa. That's a very specific one, and there are specific limits to it. But if your only performance is in the US or at academic institutions, it's definitely worth asking whether you need to actually have a visa or not, an employment visa or not. And this one's really important because very frequently we find that, a theater festival, for example, may have a relationship with a university, and they've been spending a huge percentage of their budget on getting visas for the artists who perform at the festival, and they didn't need to at all. They could have just been coming under the academic exception. There is also a specific exception for recording artists, musicians typically, who are coming to the US to record pursuant to a contract with a non-US entity. So if you're signed to a Danish record label and you're coming to record at a US recording studio, you probably don't need a visa. In all of these situations, you need an invitation letter so that if you're arriving with equipment and it looks for all the world like you're coming on tour, you can explain why it is that you don't have an employment-based visa. And those back pocket letters are things that you can get from Tamizdat for free, or if you're already working with CoveyLaw, you can go to CoveyLaw and they can help you put together those kinds of invitation letters. Um, JR,
Yes.
time for me to ask you a question. So you're arriving, you're driving up to the border from Canada or Mexico, or you're flying into a US airport. What should people actually expect is going to happen when they are face to face with a Customs and Border Protection officer?
What a great question. I haven't even thought about it, but I'm just
I know,
gonna try
right?
to I'm gonna try to answer right off the
You're gonna
top of
wing
my
it?
head. So uh, when you're entering, you are presenting yourself for inspection, technically. And I would say for the majority of people, it should be a fairly straightforward process. We don't, in our practice, tend to get into the customs aspect of, immigration and customs enforcement. But one thing to consider, and I probably should have mentioned this when we talked about like what you should prepare before you come in. Some of it's really basic. Like, are you traveling like with a bunch of fruit? Are you a musician, which is this is probably a more likely scenario. Are you a musician that's traveling with an instrument that has something that's potentially banned? A common one. I'm somebody like I'm a, nominally a musician and would travel with an instrument that had ivory on it. And is this something that is going to come up in a search? Do you have a CITES permit? Is it something that's like the CITES convention? Uh, if you know, you know, that's like if you're or an artist or performer that's traveling with something like that, be prepared to present that material if they ask you, do you have anything on you that's like that? But usually they'll ask you, what's the purpose of your travel? Why are you seeking to enter the United States? For most people, it'll be, I have an O1 visa. I'm a performer. I'm a musician. I'm an artist that's coming to be part of an exhibition. I'm a physician that is on an O1 or an H1B, and this is part of my job. Have your passport ready. Be prepared to show up for inspection. And for most people, that should be enough. There are instances where if you have a record with CBP, for instance, we talk about this example years ago. We knew of somebody that came in and they were traveling with a piece of fruit. And they said, yes, I have an orange on me. And they were not supposed to have that. And that was taken from them. But for years after that, that followed them. They had a flag on their record. So that will sometimes trigger an almost automatic, for lack of a better word, invitation to secondary inspection. Secondary inspection is where they take you to another area, usually in the airport or in that's it's also it can happen in pre-flight. So if you're coming in from Canada, where you'll be inspected in Canada, it can happen in Ireland where there's pre-flight inspection. I think Barbados has pre-flight as well. In those areas, they do have the ability to take you to another space to question you about your travel, who you are, prior issues. They may want to know why you are coming up or why there is a flag on your file. That's not necessarily indicative of trouble or a problem, but it can happen. So if you are taken into secondary, don't immediately panic. Some people are just randomly selected for secondary inspection as well. It doesn't necessarily mean there is a problem. We're going to talk about device searches in a little bit and what to expect in terms of will my device be searched? Can it be searched? What should I have? I'm going to leave it to Matthew to talk about the contents of devices, but uh, it's interesting. We were talking prior to this presentation about some statistics that CBP has released, and they claim, whether or not we believe it, I'm going to choose to believe it just for the purposes of this call, that less than 1/10 of 1% of travelers are subject to a border search of an electronic device. Does that mean that statistic is following what is actually happening? It's hard to say. I have not had a lot of clients say they've been subject to search. Um, it's going to be probably case by case. CBP claims that for the most part, they're not going to be going after people for search unless there's a reason for it. From what we're reading and from liaison notes from this is from October of 2025, there are some things that will trigger searches of electronic devices. So, relationship with an employer that is potentially someone that they are investigating, that may do it. Uh, and I think for a lot of O1s, that's maybe not something that's going to come up. I think that's probably going to be something that may happen in an H1B context. But, Matthew and I were talking beforehand. I think if you are on OPT and the OPT employer was subject to an investigation, there was a series of OPT employers that were considered to be fraudulent. They were set up by Chinese shell companies. This is going back 7 or 8 years now, but it caused a lot of issues. And some people were being stopped for search based on those relationships, and their devices were potentially being subject to search. Um, CBP generally is, I wouldn't say they're expanding search, but it's been more expansive, and it's been since as early as 2017. We know that there has been more consistency in the search of devices. Uh, what's interesting is that the CBP policy on their website is that if you are a non-immigrant, you do not have the same protections that obviously a citizen has. You have much fewer protections. And CBP can say, without warrant, we want to take a look at your device, and you can say no. And CBP's policy on the website is that simply refusing to uh, allow your device to be searched should not be, or may not be, prerequisite for a denial on its own. However, CBP at JFK has made it pretty clear that if you do not comply with that request, they will deny entry. So that is something to consider. And I think one thing to think about when we're talking about searches and when we're talking about what CBP can do, it's what Matthew was talking about at the very beginning of the call, what the perception is and what the reality is. Uh, the problem is we're in an environment right now where the reality of searches, the reality of requests to search electronic devices, it's hard to trust the information that we're getting, for better or ill. And we're not here to make a commentary on the current administration, but a lot of people on this call are probably feeling a little bit nervous about entering and not knowing what to expect. And even if CBP's goals are relatively innocuous, if we're trying to give them the benefit of the doubt, which I don't know if we can right now, it's still going to be really scary for most travelers because we don't know what to anticipate. And again, Matthew's going to talk a little bit more about best practices, I think, in terms of what should be on a device and what should be on social media. But just be aware that it is something that you could encounter. But CBP's own reporting and our anecdotal experience has shown that there hasn't been an increase in those searches or search requests. I think we did see an increase in 2024 and 2025. Uh, I haven't seen anything more recently, but the thing we talk about in immigration and really in all, practices of law is everybody has a friend. And sometimes your friend is maybe not maybe not our friend because they'll tell you something and it might not apply to you specifically, or they may be misremembering an interaction or the circumstances of how something came up. So if somebody was searched on their own, it may be a very different circumstance. So, I don't want to spend a ton of time talking about this, but I know that, in reading some of the questions that were associated with this call, people are concerned about what are the chances of my device being searched. You are subject to search. It can happen. You do have to potentially present those devices. Uh, Again, CBP is claiming that it is not as common as what is being reported. And in terms of how the search is conducted and what can be conducted, again, we could spend a lot of time talking about this. I'm not going to get into the weeds. In theory, they're supposed to search, in airplane mode. If it's an advanced search, they're supposed to get supervisory approval. There has to be oversight of that search. Uh, Especially if it's a locked device and they're trying to bypass password protections or encryption. Uh, it gets very complicated. And for this call, I want to limit it to say it is possible. Compliance is probably going to be the best idea if it comes up, if you want to come in. But that becomes a question of personal liberty and choice. And I am not in a position to make that decision for people on this call and for even my clients. I can't make that decision. I can only give you advice. And as attorneys, especially the kind of work that we do, and I think Matthew is going to talk a little bit more about it, we're balancing equities. So it's in addition to law, it's sort of balancing the idea of what should be done and what has to be done or what can be done. It's that justice idea that comes up a lot. So it is something that you should, if you're worried, definitely talk to Tamizdat about, talk to a lawyer about, uh, because there are a lot of considerations that will go into it, and we're certainly not in a position to, if you have a very closely felt position, and the thing that was coming up for a lot of people early in this administration was support of Palestine or potential attendance at rallies, and having documentation on your phone or data that reflected participation. There was a lot of concern on how could that information be used to potentially keep you out of the United States, or if you're already in the US. We saw plenty of people who were being detained based on participation, or even having documents on their phone that showed that they were potentially in support of some of those political ideas that the administration doesn't support right now. So, I'm already getting a little bit too far down the rabbit hole. So searches can happen if you're worried about it. I hate saying talk to a lawyer, but this is a case where Tamizdat, CoveyLaw, that's something that we're kind of here to chat with you about. Does that make sense, Matthew?
Yeah, I think that makes sense.
Okay.
Um, just quickly, do you want to run through what happens if you are refused entry?
Yeah, I think basically, refusal of entry, they can send you back to your home country. You're looking at potential loss of ESTA based on a denial, so that's something to think about. We talked about what ESTA is. It's basically the electronic system that follows the visa waiver program that multiple countries are a party to. And you can get knocked out of ESTA for a lot of different reasons. You can lose it. So,
Yeah, it's not the end of the world.
it's not the end of the world. You can still get a B visa to come in. Having a B visa, on the other hand, is kind of a pain to get right now. Uh, but we also have contacts that can help people navigate that. But it is super complicated. And even for attorneys, understanding ESTA and the loss of ESTA, and what triggers that sometimes, because ESTA initially, for those who aren't familiar with it, or if you are somebody that's part of an institution that is working with foreign artists, you might not know the specifics. The foreign national, the traveler, applies for ESTA on their end, and they are granted that. But there are a series of questions that are asked in that process, and depending on the answer, uh, that can lead to a denial of the ESTA request. So it's something that, if you are working with an artist that potentially has, a criminal issue, that's something you should. It can be sensitive, and that's one of the jobs that we do, where you might not be in a position where you can ask those questions, but counsel sometimes can. And because of the privileged nature of the relationship, we are able to give advice. We maybe not be able to tell the arts organization everything, but we can help that traveler and help them answer questions. It's going to be a little bit different than the consular process too, because I noticed in the questions and answers that came up, or the questions that came up before this, people were looking for answers about consular processing. It's a little bit different than the CBP process. That's probably another office hours discussion,
Okay, definitely.
but that's uh, for, at least I think that covers the basics of like ESTA and what
Okay.
happens if you're denied.
Okay.
Uh, so this is like, since we're getting into some of the more sensitive stuff, Matthew, and especially under this administration, something that's come up that I think is really important and is very difficult to navigate will be how the administration is looking at gender right now, and non-traditional ideas of gender and how people are approaching it. And we're going from, a very different climate from the prior administration to the current administration. So could you
Right.
maybe talk a little bit about what's happening right now, and especially for people who are worried, or just people who have friends who are worried? Tell us a little bit about that.
Sure. Yeah, I think, we went into this administration very worried about how the evolving policies from the US government would affect transgender, gender nonconforming, intersex people and what they would experience at the borders. So first of all, I want to say that our colleagues Will Spitz and Lee Clark did an office hours devoted to this topic last November, and that can be found on CoveyLaw's archives, which is linked from sort of a red bar on our homepage. So that's an entire hour devoted just to this. And even though it was in November, we haven't really seen much of a change since November. Uh, we are not seeing trans, non-binary, or intersex people being denied visas on account of that aspect of their person. We have seen some delays, usually related to the U.S. government trying to figure out exactly what is the difference between the original birth certificate, perhaps an edited or an amended birth certificate, a foreign passport that lists one gender, and what is possibly what the applicant is putting on their being required to put on their U.S. visa application. If there are discrepancies between those, if there's differences between those documents, we are sometimes seeing visa issuance being delayed as the U.S. government feels like it needs to figure out what's going on here. But we aren't seeing people being denied, and we aren't seeing significant delays. It's not like it's people are waiting for months or years for those things to be resolved. Um, in regards to entering the US, we have not seen people who are having problems entering the US who have a gender marker on their visa that is different from the gender marker on their passport. And this is important because the US visa forms now require visa applicants to list their sex as assigned at birth, which, if it doesn't match their current gender or the gender marker on their passports, that could lead to people having a lot of anxiety. You know, if the original sex assigned at birth is different than what you have on your passport and you have filled out your US visa application either doing what they want you to do, which is put in your sex assigned at birth, or what many people want to do because it's their actual gender, put in their current gender, there's going to be a discrepancy between the documentation that's out there in the world. And that understandably can cause a lot of fear and anxiety. And I have to say, it's a perfectly good reason why many people are not wanting to come to the US, just having to face that. But it's important to understand that in practice, we are not seeing this as a problem. We are seeing, again, people arriving and having different different markers in different documents. And sometimes we're seeing Customs and Border Protection officers taking a minute to be like, hang on, what's going on here? And I can't promise that they're going to be polite because sometimes they're not. But people aren't being turned away because of that. Um, I will say though that if your name has changed, so there's a mismatch between your passport and your visa, you may want to bring the documentation of your name change when you enter the US, just to help officers understand the relationship between the documentation. There's a lot more about this topic, especially when you go past the what just happens at the border. But again, I refer you back to Will and Lee's office hours from last November for an in-depth look into how the evolving U.S. policies are affecting travel to the U.S. for transgender, gender nonconforming, and intersex people coming to the U.S. Um, JR, I got a question for you. This is sort of more nuts and boltsy, so we can probably burn through it because we haven't got a ton of time left. Um, what should people do once they clear the passport and customs control? Are they just fine and they should just like, okay, I'm in. All problems over. Wait, you're on mute. Um,
Good, because I
there-
was saying nonsense.
okay.
So now nonsense is over. Nobody had to hear it. Now just the regular nonsense. Uh, there are a couple things that I tell every client upon entry. I-94, I-94, I-94. If you don't know what it is,
What's an
learn what it is.
I-94?
I-94 is the electronic system that monitors entries and exits and status in the United States. It used to be, and still is, a little piece of paper that was sometimes issued at the bottom of your approval notice, sometimes stapled into a passport. But now it's all online. And if you are on a non-immigrant visa, or if you even, I think, as a foreign traveler, if you're coming in on ESTA, you can look up your I-94. You can go onto the I-94 website. If you've been in communication with anybody at CoveyLaw or Tamizdat, I think all of our signature blocks have a link to the I-94. I-94 is super important because it is really the best evidence of your status in the United States. So you can get approved for classification for an O1 visa or a B visa or whatever else. But until you enter the US, you don't have status. Status is like a cloak that is placed on you when you come in the US, or it's like a robe you get at the spa. It's temporary. When you leave, it stays in the US. But when you're here, you have it and you are in that status. You want to make sure that the status you're assigned under the I-94 is correct. So if your O1 visa or your visa says O1, you want to make sure your I-94 didn't say H1B or another classification. And you want to make sure, which is really important, that the admission date or the admittal date, the entry date is correct. So, what can sometimes happen is CBP can make a mistake. They do that really frequently. So, it'll be the wrong visa classification or the wrong date. Or maybe you forgot to request a 10-day grace period. So, it doesn't have those extra 10 days that you were hoping, you were relying on to exit. Um, that's really important to consider because there are instances where CBP will correctly truncate that approval period or that entry period. So you could have a passport that expires in 2 months from entry, but you have a visa that's still good for 2 years. CBP will correctly limit your admission period to the passport expiration rather than the visa expiration. It's rare, but it does happen, and it's right for them to do it. It's not an error. It's going to be based on that earlier, usually under 6 months of the passport expiration. Uh,
JR,
yeah,
I'm gonna cut you off just for a second. I want to come back to some of the other points that we want to get to
yeah.
about what to do after you clear, because I really want to, because we're running
Okay,
pretty
yeah,
close on time here, and I want to
yeah.
jump
Check your
into the
I-94.
social media. Check your I-94. That's the main thing. So I want to get onto the social media topic just because I think there's so much concern and question about that. A lot of people are really worried about the US government checking their social media and potentially denying them entry to the US because of political content they find there. So I want to talk a little bit about this. Many people coming to the US are concerned about US immigration officials demanding access to their social media and that their entry to the US may be jeopardized. At the same time, we know that instilling fear of this happening it promotes self-policing and self-censorship. So while it's important that people understand the risks they face, also we want people to appreciate that at least so far, none of our clients have actually encountered significant delay or denial due to social media content. So I want to go over some of, and this is what, JR was saying, is that less than 1/10 of 1% reportedly are actually being inspected, having their social media, having their devices inspected. So I want to give you some of our best guidance based on best information we have right now. Um, so, what are the chances I'll be asked about my social media? The chances are real. You should take the topic seriously. But again, it happens very, very rarely. So, as a rule, unless there's something in your record or something about your nationality that is going to cause them to take a second look, chances are extraordinarily slim that they're going to pay any attention to your social media. So if you've had a prior visa violation, or if you're coming from the global south, or specifically a Muslim majority country, there's a higher chance that they're going to be looking at it at your social media. But if you are not, there's a very, very, very low chance that they're going to care. Um, JR already talked about, do I have to allow immigration officers to access my social media accounts? There's a lot of law and a lot of discussion about this, but what it kind of amounts to, JR, I think this is fair to say, is no, probably you don't have to. But if you don't, chances are pretty slim that you're going to get into the US. The fact that you say, no, you can't look at my phone, you can't look at my social media, is probably going to be the reaction is probably going to be, well, that's fine, but you can't come to the US today. Um, a lot of people ask if they should proactively make their accounts public. That's part of a requirement in certain visa application classifications that has come out in the last year. Should you make your accounts public? Well, that depends on your status and on your risk tolerance. At the border for visa waiver and visa travelers, social media disclosure remains largely optional, though CBP is currently using automated scanning techniques, so we may be seeing stricter enforcement in coming months. US citizens, which isn't really what we're talking about today, are not required to make their social media public, but Customs and Border Protection officers have broad authority to review publicly accessible social media. So they may even search your electronic devices, or they may use their own computers to search your social media. It should be noted that if you are applying for a visa, the U.S. State Department mandates that certain visa applications, such as the H-1B, student visas, and exchange visas, make their social media profiles public. In practice, we are seeing consular officers very, very, very rarely demanding this, but failing to do so or hiding accounts during the application or consular interview process can result in visa delays or potentially denials. So should you make your accounts public? Probably don't have to. They're probably not going to notice. But it is a topic that you have to take a certain amount of you have to take seriously to a certain degree. This is a big one we get all the time. Should I delete political social media posts from my account, or should I just completely delete apps before passport control? Unfortunately, there's no really simple answer to this question. CBP officers have a broad authority to search devices and publicly accessible accounts, but they rarely do it. And deleting posts or apps may actually create more problems. Um, because oftentimes deleted content can still be accessible. It's highly unlikely Customs and Border Protection will bother to look for it. Um, but if they are looking for it and if they're determined to find stuff, they will probably be able to find it. CBP utilizes specialized forensic tools that can recover hidden, cached, or deleted content from electronic devices. And if it gets really heavy, the US government can work directly with social media companies like X or Facebook through legal channels or data requests to access deleted content. Chances are, again, for the vast, vast majority of travelers, their social media is completely uninteresting to the US. However, if you are concerned that there is something in your social media that is a priority concern for the government, you probably should seek guidance. So, what this boils down to is if you've got the random Trump is a moron social media post and you're coming from the global north, and that's it, chances are very, very, very slim anybody's going to care about that. If you are coming from a country that is at odds with the US, if you have an Iranian passport, if you have a Syrian passport, if you have a Palestinian passport, um, and you've got social media that could be viewed to align you with those governments or organizations that the US government sees as antithetical to its goals, that's where things start to become a problem. And that's where social media that makes it look like you have an alignment, you are somehow aligned with Hamas, for example, that could become a problem. They might look because of your passport, and what they find could cause you a problem. Again, deleting everything can raise red flags uh, because CBP, if they are suspicious of you, they're going to be able to find out that you've deleted everything. So that is not necessarily the way to go. I've just kind of burned through these topics really quickly um, because we're running out of time, but I just wanted to touch on those topics. I think we probably are going to be some questions here. Should we take a minute to ask questions, or do you want to finish the last section that you were working on before, JR?
The entries. The
Yeah.
couple things just to think about with the I-94. My colleague Kim Xavier, thank you, brought this up. The I-94, the way they determine timing has changed in I think, the last year, and it's based on uh, Eastern Standard Time or DC time, and why that is important, and it's crazy because as we were talking about it yesterday, and then a client asked me about it about an hour later. If you're departing on the last day of your admission period, your entry period, and let's say it's the 15th of August, and that's when your I-94 expires, your O-1 entry expires. and you are leaving at 9 o'clock Eastern Standard Time from New York, probably fine. But if you're leaving from California at 9 o'clock, then that is midnight in Eastern Standard Time. So potentially you are technically you have overstayed. And that can be a problem down the line when you're trying to renew a visa or trying to, like, if you're ever trying to get an interview waiver in the future, it could be potentially problematic. But it's a weird small thing that changed that can cause a problem. If you are somebody that may need extra time to leave or want extra time, requesting a 10-day grace period that many of the visa categories, that at least with the visas that we work on, uh, allows for, that's something to either ask when you come in, or it's something to talk to your attorney about with one of those back pocket letters. Because not only are you worried about what happens when you enter the United States, it's how you leave the United States. We know that CBP is getting better at exit capture and trying to affect a departure or help people affect departure. Um, for the most part, CBP has stated that its goal is not to interfere with people departing, although in some cases, if there's a law enforcement issue, if there's some issue of criminal exposure, that can potentially come up. But you should be thinking about how you're departing, the timing of the departure. That's going to be really important. And a basic thing that comes up a lot of the time, and we've talked about it internally, is how do you document your stay in the United States? Is a visa enough? I think most of us, we want to limit the exposure of clients and showing personal documents to law enforcement. Um, and we don't have a lot of time, so I'm not going to get into like how much, the jurisdictional or the operational area that CBP and other law enforcement have to conduct immigration investigation. Just know that they do have an expanded jurisdictional range, and that if you want to print out a copy of your I-94 to carry with you to show that you are currently in status, that could potentially save some issue in the future. I don't know if people necessarily need to worry about doing that. Just be careful. Be mindful of places where there could be more enforcement or more investigation of immigration. So places near the border, especially tourist areas near the border, like Niagara Falls, for instance, is a place where they're conducting more stops. Uh, any kind of port of entry, so an airport, but also Port Authority in New York, where we're seeing they were reports of ICE activity around there, and like CBP, ICE is also part of that enforcement effort. But other law enforcement agencies have also been tasked and given greater jurisdictional range for doing immigration stuff. So be careful. And for those in New York, stay out of weed shops. You are not allowed to participate in that activity under federal law. So don't be in places that could potentially invite law enforcement or scrutiny to your immigration status that would eventually or potentially get you in trouble.
Thank you. Thank you, JR.
You're so
I just,
welcome.
while you were talking, I just cleared the questions that had come in the Q&A. Um, we do have a couple extra minutes, so if anybody has more questions or that have come up that they want to put into the Q&A chat, please feel free to. Otherwise, I think we've covered everything we set out to talk about. Um, I think so. I'm just looking through our notes here. JR, is there anything we missed?
Not for CBP stuff. I'm seeing in the questions that there are people asking some additional questions about green cards, about the Dorcas decision, the pause that's affecting adjudications
Oh,
for
right.
people. That's a completely separate, probably office hours topic. Uh, I would
Right.
say reach out to Tamizdat, reach out to Covey if you're somebody that's looking at, planning on applying for a green card. We do consultations about those. In terms of if you are affected by the current adjudicatory pause and are wondering what current or recent legal action, if it's affecting things, reach out to us and we can help you with that. It's a much bigger topic than we can answer in the next 5 minutes.
Right. Someone just asked if we have a situation at the airport and need support, who should we call?
Tricky.
Tricky, tricky indeed, because usually If you're arriving in the US and you're pulled into secondary questioning, you usually don't have access to your phone and don't have access to legal support at that point.
Yeah, CBP
In
has said that there is no right to counsel. You do not have right to counsel, or your attorney can't come and talk to you as a non-immigrant.
Now, that is true, and yet there have been many situations that we have dealt with where we get a call from whoever's at the airport meeting someone, or and the person doesn't come through immigration, and it's been an hour. And we've also had situations where somebody's able to use their phone for a little while, and we find out that they're being questioned about something. And we've had situations where we end up calling Customs and Border Protection at the airport saying, like, hey, it looks to me like you're detaining my client. Let me help you understand what they're here to do. So there are sometimes situations where we can help, but I think that it's certainly not every situation, and that is it's rare. That to your basic question, what do you do if you need support? Um, Probably there's not a lot that anybody can do to support you in that situation. Once you are being detained, you kind of resurface when you go get back to your country and try to figure out what happened.
Yeah,
So I don't have anything particularly positive to say in answer to that
not to
question.
terrify anybody, but they can hold you in secondary for up to 72 hours. I don't in practice that's not very common unless you've done something or there's some issue that they're trying to get to the bottom of. One thing we tell clients is have an action plan. So somebody that knows your travel plans, have a phone tree, who to contact if they don't hear from you for a specific time. If you do have a lawyer and you're worried, uh, let us know when your flight's supposed to arrive. When we can. If we see that you're supposed to come in at 3 o'clock at JFK and nobody's heard from you at 6 o'clock, that's a good trigger for like a parent or a friend or a relative to email your lawyer and say, hey, we haven't heard from so and so. We're a little bit concerned. And then what Matthew was saying is we are fortunate, like we have a pretty good relationship with certain posts and certain CBP units. So there, and some are more inclined to communicate with us than others. Like JFK, we talk about it a lot. They are very professional. They're pretty good at their jobs, and they are willing to, for the most part, talk to us, even though they'll say no right to counsel. We won't even let politicians come back and find people. They are willing to, in certain situations, communicate. So having an action plan, if you're worried, is going to be something that you can at least have come in with peace of mind.
Yeah. Shannon, I see your question. Does someone coming to adjudicate a competition need an employment visa? That's going to really turn on what's their contract with the event, and what kind of compensation, if any compensation or expenses are being covered by the competition. So I'd encourage you to reach out to Tamizdat Avail for an answer to that one. Uh, would we have the right to film if we feel nervous about the situation we find ourselves in? Jared, do you know an answer to that? It's a moot point if we aren't allowed our phones. Yes, it is a moot point. And also, there would be no faster way to antagonize them. So if what you're trying to do is get into the country, I'm not sure that filming is going to help convince them to let you in. On the other hand, if that seems like a lost cause and you for some reason still have your phone, uh, I don't actually know if you'd be allowed to. I'm not sure what the law says really matters that much at this point. I think they may tell you not to, whether you have a right to or not.
And it
But I
also depends on
that.
where you are and where they
Yeah,
take you. So
yeah, where in the process
that's
you are.
that's an it depends, I think.
Yeah, exactly.
But
I
probably
mean,
but probably not the best idea, depending on if tensions are high. If somebody else is filming, that might not be the worst. But
the last question here. One of our invited artists was asked to change their return flight tickets as it was scheduled on the exact end day of their ESTA. Well, that's a very specific question. I would reach out to, is there legal grounds for this request? I think it's probably good advice, actually, from CBP to have a to be in a situation where a flight delay could cause you to overstay your ESTA that'd be a bad situation to be in. You don't want to be in a situation where you go out of status just because the flight got delayed. So I don't know that there's legal grounds for it, but it would be something that I would agree with the officers if somebody came to me and said, "Should I change my flight to avoid the possibility of going out of status on ESTA?" I would say, "Yeah, you should because that is, the risks far outweigh the the rewards of that." I think we're done. It's at 11 o'clock. We're wrapping it up at exactly the right time. Thank you all for coming. We will be back next month with the next office hours, and this will be archived and available on the CoveyLaw website probably within a few days. And so thank you and appreciate everybody taking the time out to listen to us today. And thanks, JR. Appreciate you too.